Good morning. I'm Siobhan Horan and I work for Knowledge Transfer Ireland, and I'd like to welcome you to our webinar this morning. This is the latest in our Unlocking Knowledge Transfer webinar series, and I'm sure many of you are quite familiar with how we run the series now. It's set up really to shine a spotlight on the wealth of knowledge, technologies and skills available in the Irish research system, and also the means by which industry can collaborate with the research system to commercialise new technologies and ideas. So after every event, we ask for your feedback, and one topic that is coming up consistently is that around Brexit and how your intellectual property may be affected. So for that reason, we've organised this morning's session around that topic, and we've invited in 3 experts to answer any questions that you may have around that. So I'm going to introduce our experts now. They are David Brophy, Partner and Patent Attorney at FR Kelly. We also have Stephen Donoghue, Knowledge Transfer Case Manager at Nova UCD, and we have Joe Doyle, IP Manager at Enterprise Ireland. So just before I hand over to our panelists, I'm just going to say a few words about the format of the webinar this morning. So our panelists have prepared a short presentation that will outline the key changes that you should be aware of. And then after that, we're going to have a discussion and we're going to take your questions. So I would welcome any questions that you may have. You'll have a panel on your screen where you can submit your questions to us. And also just finally to say that this webinar is being recorded and will be made available to you afterwards through the KTI YouTube channel. And we'll also be circulating our panelist presentation this morning. So with that, I'm going to hand over to David.
Thanks, Siobhan. Good morning, everybody. So we, as Siobhan said, we have a brief presentation where we're just going to run through the main areas of IP and the changes that people might want to be aware of in those before we get into more depth, maybe with the questions. So I'm going to start off talking about patents, trademarks and designs, and then Steve is going to talk about copyright and trade secrets and some data protection issues, and then Joe has some talk about some funding that's available. So I'm looking at the main areas, patents, trademarks and designs. I think it's important to say at the outset that the UK government throughout the Brexit process and the Brexit negotiations, or at least the UK Intellectual Property Office, they said they wanted to make it as smooth as possible for business. So they wanted as little impact as possible on the IP of businesses. And they've done what they can to make that happen. In the area of patents, there was very little that they had to do because although the UK is a member of the European patent system, that's not an EU institution, it's not an EU body, it's an intergovernmental organization, and so they remain part of that system regardless of Brexit. And the way that applicants are going to interact with the patent system in Europe and the UK doesn't really change. You can still apply for a UK patent, you can apply for a European patent. If you apply for a European patent, you can designate the UK along with all the other countries and you will get protection in the UK. So there's very little that you have to do on patents. There are minor changes in the supplementary protection certificate system, which is a patent extension for pharmaceuticals and a few other types of regulated products. But again, they are minimal in terms of what people need to do. And then the area I think that's going to be most affected, there have been efforts for many years to try to get a unitary patent where you would have effectively one patent covering as many European countries as possible, so that if you have an infringement, you can go into court in one country rather than suing in all of the countries. You can sue in one country and resolve the dispute for all of the participating countries. And that was designed around the UK being a central part of it. And with the UK dropping out, that system is less likely, I think, than it was before, or at least if it's going to come into force, it's going to need changes and maybe major changes. And there's questions over how attractive it will be for businesses without the UK being part of it. So the unitary patent system has had a difficult beginning anyway, and Brexit hasn't helped. In trademarks are part of a harmonized European system. So there's an EU trademark office that grants EU trademark registrations, and obviously the UK no longer forms part of that. If you had an EU trademark registered by the 31st of December 2020, then effectively that's just been cloned onto the UK register. So there's a duplicate registration now in the UK, which you will renew separately going forward for your protection in the UK. After the 1st of January, you have to apply separately in the UK and the EU. So there's going to be some additional costs there for companies where they have to get both registrations to protect across the European market. And then there were cases that were pending that had been applied for before Brexit, but were not yet granted. And for those ones, you have to reapply in the UK, and you have until the end of September to do that. The final thing on trademarks, there's a requirement that you use a trademark for it to remain valid, and you're now going to have to make sure that you use it both in the UK and in EU countries as well. Previously, substantial use in one UK country was enough to keep your trademark registered. In the design system, the designs are very, very similar to the trademarks, and it's the same scenario in terms of dates. If you had a registered EU design, registered community design, on the 31st of December, you now have a parallel, automatically free of charge, you have a parallel UK design registration. If you had something that was pending on the 1st of January, then you have to reapply in the UK. And obviously for any new designs, you do have to apply in both jurisdictions. And then my final point is just on unregistered design rights. These are three-year rights that you have automatically when you put a product on the market in Europe. And if you had one of those as of the 31st of January, then you get the remainder of the term in the UK. So they've created a parallel right in the UK. And they've created their own new unregistered 3-year right that's going to mirror the EU right. The difficulty with that is that you get this right when you disclose it in the EU, and you get the UK right when you disclose it in the UK, and you have to disclose it first in that jurisdiction to get the right. So obviously it is normally very difficult to disclose it simultaneously in 2 jurisdictions. Whether you can do that on the internet is an open question. It's probably your best bet, but you want to be careful. If you want these unregistered rights, be very careful about where you first disclose your design, because that could affect whether you get protection or not in either the EU or the UK. And the last point is that the UK has always had, or has had since 1988, has had a 10-year unregistered design right that's unique to the UK, which we were able to avail of, or businesses in Ireland or in the EU were able to avail of. And as of the 1st of January, you're no longer qualified to avail of that right. So it's only open to UK designers and UK businesses. So we've dropped out of that system, and there is no parallel European system for that. So with that, I'll let Stephen start to tell you about some of the other rights.
Thanks, David. So I'm going to be talking about copyright, database rights, trade secrets, GDPR, obviously not strictly an IP issue, but kind of has associated feeds into some IP issues, and also wrap up on just a slide on kind of European funding, because some SMEs may have relationships with British universities or British companies, and you may want to kind of have a very quick overview on where the UK stands with regards to European funding. Okay, David, next slide. So for copyright, there essentially won't be much changes. The majority of copyright laws have been derived from Europe, and these have been implemented in the UK. However, one big issue is that there is no plan currently in the UK to implement the EU Copyright Directive. The EU Copyright Directive deals with the kind of relationships between content creators and the platforms, and essentially tries to create a more level ground for content creators in dealing with these platforms. So it really kind of relates to music, broadcasting rights, those kind of things. But as I say, there's no plan to implement that directive. Database rights, that kind of relates to what, it's kind of similar to what David was talking to with regard to unregistered rights. It's slightly complicated in that that was an EU directive, and going forward, there will be, the UK will create its own database rights. And database rights relate to the kind of right that for people who kind of maintain or create and maintain a database, a sui generis right. So essentially, up to the 1st of January, database rights existed for both EU and UK, but afterwards the UK will create its own database right, and the EU will have its own database right. So UK companies will not, unless they have a kind of place of business in the EU and are maintaining the database in the EU, they will not have a database right, and vice versa. David, next slide. So again, with regard to trade secrets, there's no changes anticipated in this area. The UK has a very strong history of maintaining trade secrets and protecting know-how, and a very strong kind of history of kind of confidential information agreements. In actual fact, the UK kind of contributed enormously to the Trade Secrets Directive. So the EU Trade Secrets Directive was implemented in the UK and will remain in effect. The only issue, perhaps, which we can discuss, is kind of issues around jurisdiction, but we can discuss that if you want. So as I said, GDPR, not strictly, obviously, an IP right. However, this is one of the issues that is probably going to become quite contentious. Under the existing trade agreement, the UK is not to be treated as a third country for an interim period up until for 6 months up until January. But discussions and negotiations are ongoing around this, and essentially what's happening is the Commission is kind of assessing whether the UK is adequate with regard to protection of the rights of EU citizens. It's probably been used as a bit of a bargaining chip, and at the moment it's still quite uncertain as to whether the UK will be granted an adequacy decision. Next slide, David. So final slide is on kind of European funding. So as I say, some of Irish companies may have strategic relationships or collaborations with British companies and British universities, and they may be kind of collaborators in European funding. So the UK is still participating in the ERC, the Marie Curie funds, the 6 global challenge clusters and missions, the partnerships, and the EI, the European Institute of Innovation and Technology. The UK is also associating with the full Horizon Europe programme. However, the main exception is that the UK is not participating in any financial instruments of the EIC, so it's not participating in the loan equity instrument of the accelerated programme of the EIC. Okay, that's it. Next slide, thanks.
Okay, good morning, everybody. So that's over for me. So as Stephen and David have outlined, you can see that there are a lot of different forms of intellectual property, lots of different regulations that come into play when it comes to managing your innovation and trading within the European Union and now the UK post-Brexit. So all I want to outline here is how we are hoping to support companies to develop a strategy around managing all of that IP. Your IP is a fundamental part of developing a trading relationship with any jurisdiction. Now, the jurisdiction in Europe has become more complicated, so maybe your IP strategy going forward needs to become a little bit more complicated as well. But one way or another, regardless of Brexit, a company needs an intellectual property strategy. So this grant scheme is a relatively new scheme that we launched, and its aim is to help companies that are performing innovation, doing research and development, to develop a strategy to meet their own individual needs, whatever they happen to be. So the main details of the scheme are outlined on this slide here, which I won't go into in any major detail. There are links, and I think you'll be getting the slides afterwards, so you can follow those links to find more detail. But essentially, it is a scheme for R&D active Irish companies that are EI, Leo, or Udaros Naguel clients that are exporting or have potential to export, and they have a need for IP support. So the grant scheme gives some financial aid to those companies to access that IP support that they need, to bring in external IP consultancy to help address whatever the needs of the company are. and also to help the companies to develop an internal capability around managing your own IP as well, so that companies are taking as much control of the internal IP management requirements of the company as possible. So that's really all I've got to say about it at this point, but I'm happy to deal with any questions about it in the Q&A.
So thank you to our presenters. That was a really informative presentation, and I'm sure those of you out in the audience will have lots of questions. So just encourage you to start submitting your questions. Just in advance of that, because we do have quite a big audience today, we have over 100 people tuned in at the moment. We would really like to just try and gauge how prepared you feel for Brexit. So we're launching this quick poll. You'll see it pop up on your screen. So if you wouldn't mind just giving us your answers, and we're just going to take about a minute or two for that. You can see the responses coming in. So far, we've got a very well-prepared audience. And now I think I've jinxed it because we're going back to about 50-50. We have about 40% of the votes in at the moment. So I think we're going to keep it open for another few seconds and try and get that up, try and get it up well past the 50 mark. So if you haven't already submitted your vote, please do go ahead. We're still a very well-prepared bunch at the moment, just looking at the results. So I think, Rowena, if you want to close that poll, I think we have a definite winner coming out from our polls. So over 60% of our audience do feel that they have considered the impacts of Brexit and feel very well prepared. You should be able to see those results now. So that brings us to our discussion with our panelists. So unfortunately, I can't see them at the moment. So I think we're going to have to take down the poll. I'd love to see the lovely faces of our panelists as I ask them your questions that were submitted in advance. So I see you all back now. So our audience obviously have done their homework on this, and you know we're talking about how Brexit may affect intellectual property, and we're also very aware that it's now April, so Brexit has already happened. So I'd just like to ask our panelists, you know, what steps should our audience members be taking in the short term to ensure that their IP remains protected in the UK? Is there anything that you think in the immediate term should be done that people should be looking at? Joe, I'm going to go to you first, since you're after leaving us on the note of an IP strategy. So how should we be looking at our IP strategy to make sure we're prepared for this?
Well, actually, I think probably the first thing is to talk to someone like the other two panelists here. I think what's really important is to seek appropriate advice, because you know, Brexit has brought a huge amount of uncertainty to a lot of the things that we do and that businesses are trying to do. And it's how I guess the first step is, how do you try to address that uncertainty? And that means bringing in some expert in the field. Some of the first things that have to be done, I think, are around that management of your existing IP rights, making sure that that housekeeping is all in order. First of all, being clear about the dates. Maybe David could expand on that a little bit. But I would say that would be my thing too, because the level of uncertainty is so great around Brexit, and it's evolving all of the time. Brexit happened in January, but there are things coming down the line. So it's about managing uncertainty and getting the proper expertise to help you do that.
I would say, Siobhan, just as Joe was saying, use it as an opportunity to have a kind of audit of your own IP. As we were discussing, you know, the impact of Brexit varies quite considerably depending on the type of IP that you have. You know, for patents, as David said, there's very little change really. For trademarks, there's quite substantial change. I think we may discuss it later, but issues around they say copyright and software won't be that big a change, but there may be issues around exhaustion of rights and kind of licensing of software that come into play down the line. But use it as a kind of opportunity to kind of to get a handle on what kind of IP you have, and then reach out to somebody to you know, to kind of assess the impact of Brexit on that IP.
Yeah, I would have, you took the words out of my mouth, Steve. I think it's an opportunity to audit and to check. And what we've seen a lot of clients, when they do sit back and assess, well, what do I need to do for Brexit? And they start to look at what IP they have registered and where it's registered, it often throws up that, well, we never protected this, or you know, this trademark, you know, the goods we're using it for have changed, and we need to make sure that we have that re-registered. I think certainly if you're trying to manage your own IP, you know, you need to be aware of the dates, certainly for re-registering. If you had any pending trademark applications, you want to make sure that you're tracking dates going forward to renew in the UK and the EU. But I think, you know, using it as an opportunity to see what you have, what you could be protecting, what you need to protect. And we have had, you know, clients who've come to us with Joe's scheme where you know, we go in for 3 days and do an audit of their IP, and we sort of say, well, here's a strategy for you, here's the things that we think you should be putting some emphasis on, and then it gives you something to work on going forward. So that's for any SMEs out there. I think that's a very useful way of getting to grips with it.
Yeah, I think it's, sorry, go ahead, Stephen.
No, go ahead, Joe.
Yeah, so I was just going to say that actually that is an IP audit, regardless of Brexit or anything else, is a really great place to start with any sort of IP activity, especially if it's relatively new departure for a company, which it is for a lot of companies. And our scheme is partially designed around that requirement. While we're not really prescriptive about what a company uses a grant for, the IP Start grant, the smaller of the 2 grants that are available, was kind of designed around that level of uncertainty, and a great way to reduce uncertainty is to start with that IP audit, get in an expert and get them to look at what IP you have, maybe things that you don't have and what you need to put in place. And I think Brexit crystallized this for a lot of people, because maybe we've been a little bit comfortable in trading with the UK, and now starting to look at the complexities of continuing to trade in the UK, and at the same time looking at other territories. The IP issues start to come up where they may not have come up before, and so doing an IP audit is definitely a worthwhile starting point.
One final thing, David talked about dates. I mean, I think one date to keep an eye out for is June. I think I mentioned the trading, the trade agreement between the UK and the EU. June is a key date, and issues, say for example, around GDPR will be determined by then, and also for those kind of companies who are content creators, as the copyright directive has to be implemented across Europe by June, and there will be differences with the UK, and that the UK will not be implementing it.
And so we've spoken a lot about Irish SMEs this morning, but Stephen, I know that you work within a TTO, and we have quite a lot of academics in the audience today. So I just wanted to know that, you know, what are you doing within the university system to prepare your IP operations for Brexit? Have you considered your IP portfolio or made any changes to your operations?
Yeah, I think just like COVID, Brexit has crystallized a lot of things. So we had begun to, with regard to our patents portfolio, we had begun to file more directly to Europe. Historically, we had kind of filed quite often in the UK office, and then moved over to a PCT, but we started filing more and more in the European Patent Office. That also reflected the fact that I think a lot of technologies have a more kind of digital component now, and there's an argument to be made that the EPO is providing kind of better searches in that space, and had a more harmonized view with regard to patentability in that space. So certainly one of the big things we've done is we've kind of moved a lot more over to the EPO. And I don't know what David thinks, but there's an argument to be made that historically the EPO is kind of dominated by a kind of or not dominated, but reflects a kind of German perspective with regard to certain aspects of patents, and the UK and kind kind of Central Europe may not necessarily have agreed historically. They were becoming more harmonized. Perhaps now in the future, you'll see a bit more of a kind of separation in certain types of patent filings as to how they view kind of patentability. So yeah, a shift towards the EPO is happening at our end.
So for any academics out there, they can take comfort that the TTO is on top of everything related to Brexit. So if they have any questions, they can
I don't know about everything, Siobhan, but
we had a question from the audience that was submitted to us in advance. So we've spoken a lot about the challenges that are posed by Brexit-related changes to the IP system, but we have a question as well. Are there any potential advantages or any potential upsides to Irish SMEs and Irish academics as a result of Brexit-related changes? Joe, I'm going to ask you this because I know that you're quite a positive person by nature, so I'm going to ask for a little bit of optimism here.
Yes, optimist to a fault. So yeah, I mean, there's a great focus on the downside of Brexit, that's for sure, and there are plenty of downsides to it. I think, well, obviously a lot of people did vote for it, but I'm not so sure now if people would vote for it when we see what it looks like. But here we are, and I think it's useful to try to find an upside, even if it's not altogether too obvious. And I think, one way or another, Irish companies have to live with Brexit now. And you kind of look at what are the ways that we can, continue to trade and use what tools we have in our toolkit to continue to trade with the UK and to expand our trading options within the European Union. And the IP system is one of those tools or set of tools that companies can look to and maybe haven't looked at before or have been focused in a certain area. So there's a lot of talk about the trade of physical goods across borders and the problems with customs and so on. What IP does is it allows trade to continue using non-physical assets. Intellectual property is a non-physical asset, and there are opportunities maybe to look at licensing opportunities, joint ventures, strategic relationships, and so on with companies within the UK. And indeed, companies in the UK have a problem too, because they want to continue to trade with Europe, and so they may be looking for opportunities to make those relationships with companies within the EU, and there should be an opportunity there for Irish companies. It's very hard to formalize those relationships if the companies don't own their intellectual property, or if they're not quite sure what their intellectual property is. So I suppose it's an upside of intellectual property rather than an upside of Brexit, maybe. But for companies, I would recommend for companies to think about that. Think about how you can leverage the intellectual property, the intangibles in your business and your innovation to develop a new way of trading in this new environment and to find that upside.
David and Stephen, do either one of you want to share Joe's optimism?
Well, I think we tossed this question around amongst ourselves beforehand, and we had a fight over who was going to answer the positive upsides of Brexit question.
I lost clearly,
and Joe lost. Yeah. So I mean, I think there are potential upsides anywhere where there is a possible divergence in the legal systems in two countries. In IP, you have a change in the law in one country. Someone's a winner and someone's a loser out of that. So, for instance, the EU has become much more bullish on extending copyright into areas that it would never have been traditionally seen as appropriate for under Irish and UK views of copyright law. So, there's a case about protecting a folding bicycle using copyright, which means that folding bicycle now, instead of being protected for maybe 25 years under the design system, is being protected for the life of the designer plus 70 years, which is an enormous amount of protection. I think the UK will depart away from that, and so you will see products falling out of protection in the UK earlier than in Europe. So, there's a downside there if you're the designer of that product. There's an upside if you're someone who wants to get into that space. and is waiting for these products to expire. So I think there may be some opportunities there. Similarly with cross-border trade in goods like pharmaceuticals. There's a lot of cross-border trade now from the UK into the EU because of price differentials. And under the pre-Brexit scenario, there was a concept of exhaustion of rights, so that the manufacturer who owned the trademark, couldn't object to its own goods being moved around the EU from the UK into Germany, let's say. With Brexit, they have made it very clear that they can now use their trademark rights and design rights and patents to stop those goods from being moved across the UK to EU border. And in the reverse direction, the UK has said for the moment they won't stop those goods coming in. So there's going to be an imbalance in who can do what with goods like this. I know this was something Stephen touched on in the slides. You may have more to add on it. So I think anytime there's a change, you'll have some opportunities, and it's about being aware and being alert to stuff that's in your business area. You know, is there an opportunity there, or is there a risk there that you need to be ready for?
Yeah, I think David, just to expand upon what David said, I think one of the problems, the issues, is we still don't have a proper handle on everything. With regard to Brexit and IP, but as David said, parallel imports will probably be quite a kind of when you have a divergence of laws. So the exhaustion of rights offers some opportunities for certain sectors. I did mention it's a little bit uncertain, but experts in the UK are suggesting that there's a downside for UK. With regard to software and kind of the exhaustion of rights of software that they can't resell on software, for example, from the UK. And so there's that aspect. There's also the aspect, I mean, we've talked about the UK, but the reality is that's probably inaccurate, because Northern Ireland has the kind of best of both worlds at the moment. And so there are probably some sort of issues with regard, or some sort of opportunities with regard to kind of locating Northern Ireland perhaps, and kind of having access to both markets that people still can't really get their head around yet, but I imagine certain opportunities will open up there. One other thing, I suppose, for Irish SMEs or startups is still to be able to continue to have access to the EIC funding and the kind of financial instrument which UK, their equivalents in the UK won't have. So that's also an advantage.
I'm just looking through our attendee list, and we do have quite a lot of SMEs in the life sciences sector. And we were given a question in advance by an SME, just wondering if there are any additional considerations for companies and researchers active in the life sciences sector. We know that a lot of Irish regulations and standards are based on the UK system. So do you anticipate any further changes there?
Well, I think a lot of these, because it's such a highly regulated sector, a lot of the changes that are going to hit the life sciences sector may not necessarily be directly IP changes, but the change in licensing, the licensing regime, where the UK now has to have its own licensing. So there's going to be some overheads for people dealing with those systems. The main IP, the main life science specific part of IP that relates to this is the supplementary protection certificate regime, where you can get your patent extended after beyond 20 years on the basis of regulatory delays. That's going to continue as before, and it will still be the first time that it's the delay between when you file for your patent and or the patent's granted and the first time that you get a marketing authorization anywhere in the EEA will determine the length of extension you get, both in the UK and in the EU. So again, that's going to remain pretty harmonized. But I think in IP generally, because their main interaction is through the patent system remains unchanged. So I think it's really more in the regulatory stuff around IP that they will see changes.
And similarly, it's not directly related to IP, but Stephen, I'm getting some questions in about state aid, and obviously working in a university, state aid is something that you come across on quite a regular basis. So do you think that state aid regulations may be affected as part of this as well?
I think My understanding is that that is something that's still ongoing. State aid will be different in the UK. I think the cap is going to be different, and my understanding is there's a body that's going to be monitoring it in the UK. And it's quite a bit of a bone of contention between the EU and the UK as to how state aid is monitored within the UK. You kind of have to declare up front sometimes if you want to kind of exemption from state aid within the European system, but the UK, that's not going to be the case. You're not going to have to declare it. It's just going to be monitored and reported on. So there will be, I think there is a concern within EU, and I knew from having worked in the UK before in technology transfer, for example, that one of the kind of benefits that was posited for Brexit was that a kind of get loose of the state aid kind of problems that they would have perceived in the UK. So there is a slight concern, I think, within Europe that the UK, the issues around state aid will not be as closely controlled within the UK. But again, this remains to be played out. But there's no doubt that there will be differences between the UK and the EU. The UK are very strong on this. They wanted a bit looser, I think it's fair to say.
Okay, so I am conscious that we are coming up towards our time, so I'm just going to ask all our panelists just for some final bits of advice that you want to give to our audience. So David, I'm going to start with you because you're at the top of my screen. So have you got any parting words of wisdom that you would like to give to our audience today?
I think it's to use Brexit and use the changes as an opportunity to try to find an opportunity in it. You know, whether it's in terms of using it as a chance to review your IP and get your house in order or improve your house, or whether it's in terms of seeing that there are going to be some of these changes we've talked about are going to take competitors from the UK out of key markets for you because it becomes more difficult for them to continue, and so that may force some changes in the marketplace that you can take advantage of. And then you always want to keep, the IP is only ever a tool that supports the business. So you want to always have the IP aligned with, where is the business going? What are your plans for the business? And does the IP support that and do it right? So, I think use this chance to reassess your IP position and improve it if you can.
Stephen, I'm going to come to you next.
Yeah, I would echo what David said when we talked about the importance of using it as an opportunity to do an audit. I would say, reach out to Joe, and if you're in the university system, reach out to your technology transfer office. The reality is that this is still being played out quite a bit, but as we've emphasized, there will be opportunities depending on your sector, and those opportunities may be around kind of parallel importing. They may be kind of, reaching out more to the European market. I think we discussed before we had this, but we haven't really discussed it during the actual webinar, that if you have a trademark and you have kind of, obviously a lot of Irish companies and SMEs have relationships with the UK, you may need to consider expanding your trademark into Europe, but obviously be cognizant that there may be kind of cultural issues, and so reach out to your trademark attorney and see if you kind of extend your branding within Europe. And as I said before, if within Europe there are probably greater opportunities for Irish SMEs and spin-outs to access money now that the UK is not availing of the EIC equity funding.
Yeah, so I guess I'd just echo what the other two guys have said, and to bear in mind that the slow bicycle race between the EU and the UK is not over. That's going to be going on, and the risk for the future is how great the divergence will be. There will be divergence in lots of areas, including intellectual property. So to try to, as much as possible, keep up to date with that and try to anticipate how your strategy should be adjusted to take advantage of things as well as mitigate the risks. And I suppose, you know, like COVID, Brexit is a crisis. Don't waste a crisis. Think about opportunities to collaborate. I think particularly that's one thing that COVID in particular has thrown up, is there's been a much higher degree of collaboration between companies and between companies and universities, and collaboration across borders. So I'd give that plenty of consideration as well.
That's a really great note to end our discussion on. And, you know, as part of Knowledge Transfer Ireland, we're very much encouraging collaboration between the research base and industry, and we have a lot of tools and resources on hand to make that process that little bit easier. But it's great to know that you do have advisors such as yourselves in the system that people can come to for advice as well, because we know that there still is quite a lot of uncertainty around this topic. So with that, I'm going to draw our discussion to an end. I'd like to thank our panelists today for their input. Thank all of you for submitting your questions as well. Our next webinar is going to be on the 11th of May. It's about Irish innovation in connected health, wellbeing and ageing. So we would like to invite you to attend that. And also we will be asking for your feedback post-webinar as well. This content was devised by feedback that we've gotten from previous attendees. So if there are topics of interest to you, please do let us know. We can try and pull together some relevant expertise for you on that. So thank you again for your attendance today.
Thank you.
All right.